with y'all. Well, we were looking into everything. Okay, so yesterday we asked the question, who can sit in the room? We've been talking about that for a little bit, right? Like who can sit in the room? Today we're gonna ask a little bit of a different question. I want to ask the question, who holds the power, right? Like really, who holds the power? I'm continuing to a degree what we were working on yesterday, right? So I'm continuing my Pakistan constitutional law and mediation studies, pretty much what I told you guys I was doing at the University of London, and in preparation for assessments. So I wanted to do a little bit of learn out loud. And yesterday I uploaded some of my course material, my notes, and my mediation framework, which is pretty much the who can sit in the room presentation or live that I did a little bit ago. And I uploaded that into this thing called NotebookLM, which is like an AI resource that pretty much takes your information and puts it in a podcast. And since we live in the era and time of podcasts, I was like, oh, this is gonna be interesting. I'm like, we're gonna get into these receipts and we're gonna make sure this is good, fun, and juicy to get into. So I'm so excited. Um, and in fact, it didn't disappoint. Literally, the results were actually really, really interesting. We had a 19-minute podcast, right? I went ahead and today I decided to add my Legally Everywhere actual framework to pretty much the thing that I use as a foundation for what I've been doing on this channel to see if there was going to be like any changes in the conversation. And lo and behold, yesterday was a 19-minute podcast that they gave me, right? Today gave me 23 minutes, almost 24. So I said, let's go ahead and hear if there's any differences. We clearly know some differences because there's like that gap in difference in time, right? A couple of minutes. So we know that they found something else. But I'm curious, like basically what I want to know is if we just change just that little bit of a lens, like how much does the information change? Because we technically are having the same exact conversation, just for a different lens. So keep in mind, just like yesterday, I have not listened to any of it. I have no idea what the Notebook LM is going to say. I have not listened to it. We are going to do that together. Once again, I don't know what it's going to say. We're basically going to learn out loud together and see whether the framework change um, caused the AI to find something different in the content, which is what I'm very interested in. Keeping in mind, literally less than an hour ago, we had some events that were going on in the world, right, with regards to US and Iran. And we know that Pakistan is sitting in the middle as a mediator. So I'm just very curious, once again, how does that affect things? So I put it in to Notebook LM with the framework that I have, and I'm curious what it's going to say. I hope that you are is just as intrigued as I am to see what it's going to say. Do a little bit of study with me, a little bit of learning out loud, because once again, it's literally everywhere with child. We're looking into everything. So let me go ahead and get this background all set up for us so that we can listen because I am very excited to see what it's going to say. If I hear something like super interesting, I might pause us, or if you guys are putting something in the chat, like you have a question, we can go ahead and chat it up a little bit. But once again, I just created this just so we can kind of see what's happening. I'm so excited, y'all. I hope y'all are excited. Take this one little charger piece out my phone so y'all can hear. All right. If you have questions, put it in the chat. At the end, what I'll do, if you have questions specific to the material, what I'll do is I'll load it into this system and see if it generates information so we can once again learn out loud together. If not, I'll just take the information and we'll come back to it on another live. But once again, since y'all here, and thank you for everyone who's sitting currently here in the chat, we can go ahead and jump in and hear what it has to say. All right, so getting her started.
So I want you to imagine a room, like a really high stakes, incredibly tense room.
Oh, I can picture it.
Right. So on one side of this long mahogany table, you've got a team of negotiators from the United States. And on the exact opposite side, you have representatives from Iran. The doors are closed. The world's media is waiting outside, and the air in that room is, I mean, it's so thick you could practically carve it.
Yeah, the tension would be unbelievable.
Exactly. So here's the million-dollar question for you as a little mystery we are unpacking in today's deep dive. We're looking at a really fascinating geopolitical presentation titled Power in the Room, which analyzes global mediation. But to really understand the conclusions of that presentation, we're pairing it with a stack of comprehensive legal briefs.
Mhm.
Yes, from a University of London undergraduate law's micro credential.
Exactly. And those briefs focus on the foundational principles of Pakistani law.
Which
Thank you.
might sound like a really unexpected combination to some people.
It does, it totally does.
Because you have this broad political theory on one hand, and then highly specific internal constitutional law on the other. But the mission today is to show how one dictates the other.
Right.
We're going to explore how Pakistan's unique constitutional DNA, like its internal rule book, actually functions as a skeleton key. It creates a very rare kind of geopolitical superpower on the global stage.
I really want to dig into that concept because usually when we talk about a country's global leverage, we default to the obvious metrics, right?
Well, for sure. Military size, GDP.
Exactly. Maybe their stockpile of natural resources or geographic choke points.
Mm.
We rarely point to like the third paragraph of their legal code and say, yes, that's where their global power comes from.
We don't. But this material makes a really compelling case that we absolutely should. Because if you want to understand a nation's external leverage, how it behaves, and who it can talk to in that high stakes negotiating room,
Mhm.
you have to understand its internal blueprint.
You have to know what it values as supreme.
Exactly. And for Pakistan, that fundamental blueprint is the 1973 Constitution.
Okay, so let's open up that blueprint. Based on the briefs, right out of the gate in Article 1, Clause 1, the official title of the country sets up this massive philosophical balancing act. It is officially the Islamic Federal Republic of Pakistan.
Yes,
I'd love to break down the mechanics of that, starting with the Federal Republic part.
sure.
Mhm.
So it's helpful to view federal republic as two distinct structural concepts working in tandem. Let's take federalism first. At its core, federalism is basically an admission that a country is too complex to be run from a single desk. Power isn't hoarded in one central location, it has to be shared.
Right, it's decentralized.
Yeah.
Mhm.
In this case, power is divided between the central federal government in Islamabad and the four distinct provinces. So that's Punjab, Sindh, Khyber
Okay.
Pakhtunkhwa, and Balochistan.
So the provinces aren't just like franchise locations taking direct orders from the capital.
Not at all.
They have their own legitimate spheres of influence and local governance.
They do. And the Constitution maps this out meticulously. There's a section called the Fourth Schedule, which
Mhm.
is essentially a master list dividing up who gets to legislate on what topics.
Oh, like does the federal government handle this specific issue or do the provinces?
Exactly. And at the federal level, they manage this shared power with a bicameral legislature, meaning
Mhm.
a parliament with two houses, the National Assembly and the Senate. So that is the federal half of the equation.
Got it. And the republic half.
Republicanism simply means that sovereignty rests with the people. The head of state is an elected official, the president, not a monarch who inherited a throne by birthright.
Right.
It's a system governed by the rule of law, built entirely on the concept of representative democracy.
Okay, I'm tracking with you. If I just hear the phrase federal republic, my mind immediately goes to the United States or India.
Sure, the hardware is very similar.
Yeah, you have a constitution, you have states or provinces, you have parliament or Congress. The structure seems very familiar, but
Mhm.
the twist here is that first word, Islamic.
Mhm.
It seems like Pakistan is running a fascinating hybrid system.
It really is.
To use a tech analogy, it's like a computer trying to run two different operating systems at the exact same time. On one partition, you have this modern representative democracy, but on the other partition, you have a deeply embedded, overarching framework of divine law.
That is a highly accurate way to frame it. And it's crucial to understand that this Islamic character isn't just a symbolic nod to the country's heritage.
Right. It's not just for show.
Mhm.
Exactly. It is hardwired into the legal text. Article 2 explicitly declares Islam as the state religion. But the real philosophical pivot happens in Article 2A.
Which is the objectives resolution, right?
Yes. That resolution states plainly that sovereignty over the entire universe belongs to Allah alone, and that the authority delegated to the state of Pakistan is a sacred trust.
A sacred trust. I mean, that phrase alone represents a massive departure from a purely secular constitution where all authority originates entirely from the voters.
It changes the entire foundation of why the government exists. And it has
Evolution of the
practical applications.
Constitution of Pakistan. Like what?
Well, under Article 31, the state is actively directed to enable Muslims to live in accordance with the Quran and Sunnah. And to enforce this, the Constitution establishes a federal Shariat court.
Okay, and what do they do?
Its entire purpose is to review laws and ensure that no legislation contradicts Islamic injunctions.
Wow. And the briefs also mention that this dual framework applies directly to the politicians sitting in parliament, too.
Mhm.
There are specific qualifications under Articles 62 and 63 that actually involve their personal character, right?
Yes. A purely secular system might just require a politician to be a certain age and a citizen of the country.
Right. Just basic logistical requirements.
Exactly. But under Articles 62 and 63, members of Pakistan's parliament are legally required to meet specific Islamic moral qualifications. The text uses the terms Siddiq and Amin,
Mhm.
which translate to truthful and trustworthy.
And that's enforceable.
Very much so.
Yeah.
If a court determines an elected official violates those principles, they can actually be disqualified from holding office.
That is wild. So you really do have these two massive forces, the democratic will of the populace and the supreme authority of divine law woven into a single document. That is an incredibly complex balancing act on a macro national level.
It definitely is.
But I want to bring this down to earth for a moment because, all of this high level political theory is
Mhm.
fascinating for legal scholars in the capital. But what about a regular person?
Right.
Say you have
Okay,
a
right.
citizen just trying to go about their day, walking down a street in Lahore. Does this grand blueprint actually do anything to protect them from the state?
That is the ultimate test of any constitution. Because a
Right.
constitution isn't just about organizing the government's power, it is about building a wall around the citizen to restrict that power.
Right.
Mhm.
In the 1973 Constitution, that wall is built from Articles 8 through 28, which outline fundamental rights. These are robust, legally enforceable guarantees against state overreach.
And the sources highlight a few specific rights that seem particularly strong.
They are quite formidable. The absolute bedrock is Article 9, which guarantees the security of a person. It declares that no person shall be deprived of life or liberty save in accordance with law. And what's vital for you to understand is that Article 9, along with the freedom of religion under Article 20,
Mhm.
has a special status. They can never be completely suspended.
Wait, never.
Never. Not even if the country is facing an existential threat and is under a formally declared state of emergency.
Wow, that feels like a very deliberate line in the sand.
It is. The
Mhm.
framers were ensuring that the core humanity of the citizen is untouchable.
Mhm.
Beyond that, you have Article 10A, which was added later to explicitly guarantee the right to a fair trial and due process.
That's huge.
Yeah. And there's also a very progressive mandate in Article 25A, which places a duty on the state to provide free and compulsory education for all children
Mm.
between the ages of 5 and 16.
That's great. But what about citizens who aren't part of the Muslim majority? Does that sacred trust framework we talked about earlier leave them out?
The Constitution specifically accounts for that, actually. Article 36 places an explicit requirement on the state to safeguard the legitimate rights and interests of minorities.
Mhm.
This includes ensuring they have adequate representation in federal and provincial services.
Mhm.
And, like I mentioned, Article 20 fiercely protects the right of every citizen to profess, practice, and propagate their own religion.
Okay, let me pause you right there because I have to push back a little.
Sure.
Reading through a list of fundamental rights is always inspiring. It looks fantastic on paper. But historically, all over the world, governments, local authorities, and police forces ignore paper all the time.
They absolutely do.
We know state overreach is a reality. If a police officer in Karachi decides to arbitrarily lock someone up, quoting Article 9 at them probably isn't going to open the jail cell. So, what is the actual mechanical tool a citizen can use to force the state to obey its own constitution?
That is the exact friction point where theory meets reality.
Mhm.
If the fundamental rights are the wall protecting the citizen, then Article 199 is the weapon they could use to defend it.
Okay,
Mhm.
what is Article 199?
It empowers the high courts of Pakistan to issue what the legal system calls writs. Right.
Mhm.
And a writ is not a suggestion, it is a formal, binding, written command from a
Right.
high court judge to a government authority, forcing them to take a specific action or legally explaining why they should.
Okay, and the University of London materials list a whole arsenal of these writs. How do they actually function in practice?
Let's use a hypothetical situation based on your example of state overreach.
Mhm.
Imagine a citizen is suddenly arrested in the middle of the night by local authorities.
Classic overreach scenario.
Right. No charges are filed, and the family is completely stonewalled when they ask where this person is being held. The family's lawyer would go to the high court and file a petition for a writ of habeas corpus.
Which literally means produce the body, right?
Exactly. The high court issues the writ, commanding the police chief to physically bring the detained citizen into the courtroom and provide the legal justification for their detention.
And if they can.
If the police cannot prove they followed the law to the letter, The judge orders the citizen released on the spot. It is an immediate, powerful check on arbitrary detention.
That makes a lot of sense for an unlawful arrest.
Hmm.
But what if the state overreach is more, I don't know, bureaucratic? Say a local official just personally dislikes a business owner and flat out refuses to issue a commercial license that the business owner is completely legally entitled to.
In that scenario, you would seek a writ of mandamus.
Mandamus.
Yes, that translates to we command. The court uses this writ to order a public authority or government official to perform a duty they are legally obligated to do, but are refusing to execute.
So it forces them to do their job.
Exactly. Conversely, if a lower government tribunal is overstepping its boundaries and making decisions outside its legal jurisdiction, the High Court can throw a writ of prohibition at them.
Hmm.
It's effectively saying, stop immediately, you don't have the authority to do this.
Got it. And there was one more in the briefs that caught my eye. Quo warranto. What does that do?
Oh, quo warranto means by what warrant or authority. This is a fascinating mechanism used to challenge someone's legal right to hold a public office.
Oh, interesting.
Yeah, if a citizen believes a government official was appointed illegally
Hmm.
or doesn't meet those constitutional qualifications we discussed earlier,
The Sadiq and Amin ones.
right, they can use this writ to force the official to prove they legitimately hold that seat. If they can't, the court removes them.
Wow. So Article 199 gives the everyday citizen incredible leverage to drag the state into court.
Mm.
But there's a crucial limitation mentioned in the text. The high courts can't just act as vigilantes, right?
That is a vital distinction. Under Article 199, a High Court judge cannot simply read a troubling story in the morning newspaper and unilaterally decide to issue a writ.
Right.
They are strictly reactive.
Yeah,
They
Right.
can only utilize these powers if an aggrieved party or someone acting on their behalf actually files a formal petition.
So they can't act on their own motion. And the legal term introduced in the briefs for acting independently is suo motu, correct?
Yes, suo motu. It literally means on its own motion. High courts under Article 199 do not have that power. They must wait for the citizenry to come to them.
Now,
Mhm.
this is where the plot really thickens.
Okay.
Because while the provincial high courts have been sitting and waiting for petitions, the Supreme Court of Pakistan at the federal level has historically operated very differently regarding that suo motu power.
Very
Mhm.
differently, yes.
And that tension leads us straight into the fact that this constitution is not some dusty museum relic. It is an active arena.
It is a profoundly living document. Since its inception in 1973, it has been formally amended 26 times.
That's a
Mm.
lot of changes.
And if you analyze the timeline of those amendments, it doesn't read like a slow, steady progression of administrative tweaks. It reads like a brutal, decades long tug of war over who truly controls the state.
The whiplash is incredible. Like, you look back at the Eighth Amendment in the 1980s, and it granted the president sweeping, almost unilateral power. The
Mhm.
president could literally dissolve the democratically elected assemblies.
Pendulum always swings.
Oh,
A little over a decade later, the 13th Amendment comes along and violently strips those powers away from the presidency, shifting the leverage heavily back to the prime minister and the parliament.
okay.
And then you jump forward to the 18th Amendment in 2010, which was a monumental recalibration.
How did the 18th change the game?
It radically decentralized the country. It took a massive amount of power that had been centralized in Islamabad and pushed it down to the provinces.
Interesting.
Yeah, granting them unprecedented autonomy while simultaneously reinforcing the authority of the parliament over the executive branch.
So the pattern is clear. The president pulls the rope, the parliament pulls back, the provinces pull their way, and sitting right in the middle, often acting as the referee or even a player themselves,
Mhm.
is the judiciary.
Precise.
Which brings us to the absolute leading edge of this deep dive, the brand new 26th Amendment. This was just passed, and it fundamentally alters the rules of this tug of war.
The 26th Amendment is a direct, calculated maneuver by the legislature to reshape the power of the judiciary.
Okay, let's break that down.
Our
Yeah.
University of London sources highlight three structural changes that redefine the Supreme Court. First, let's return to that concept of suo motu.
Right. Acting
Mhm.
on its own motion.
Historically, the Chief Justice of the Supreme Court could act on their own motion. They could take notice of a public issue, halt government actions, and summon officials without waiting for a petition.
Wow.
But the 26th Amendment aggressively restricts that power.
So Parliament essentially looked at the Supreme Court and said, no more jumping into the headlines. You have to wait for cases to come to you, just like the lower courts.
Mhm.
Why did they feel the need to do that now?
It really comes down to institutional friction. Over the years, expansive use of suo motu allowed the judiciary to step heavily into the legislative and executive domains.
Oh, I see.
Judges were pausing major infrastructure projects, weighing in on economic policies, and becoming deeply entangled in political crises. From the perspective of Parliament, the judiciary was transforming into an unelected shadow government. Stripping that power was Parliament's way of building a fence to keep judges in their traditional lane.
That makes perfect sense of the friction. And they didn't stop there. They also changed how the top judge gets the job.
They completely overhauled the succession process. For a long time, there was a strict automatic rule of seniority.
Okay.
When the Chief Justice retired, the most senior judge beneath them automatically ascended to the role. That predictable conveyor belt is gone.
Really? How does it work now?
Under the 26th Amendment, a special parliamentary committee, which requires a two-thirds majority to act, now selects the new Chief Justice from among the top three most senior judges.
So, if I'm synthesizing the impact of that, it means the ultimate judicial appointment is no longer an insulated internal legal process.
Mhm.
It is now a highly political legislative process.
Yes, exactly.
Parliament is ensuring that the person leading the Supreme Court has at least some degree of consensus backing from the elected representatives.
Precisely. And the third major change reinforces this corralling of judicial power, the creation of dedicated constitutional benches.
What
Okay.
does that mean?
Well, previously, the entire Supreme Court could get bogged down in endless political and constitutional crises, which paralyzed the ordinary justice system. Now, specific, dedicated benches are structured to handle only constitutional interpretation.
Got it. It is a massive recalibration. Parliament is pulling the rope as hard as they can.
They really are.
Okay, I want us to take a breath and zoom all the way back out. We have spent this time deep inside.
Okay, so I'm gonna pause right there. Do you guys have any questions about what we've been hearing? I can already tell you just based off of where we are. We only have, I'd say, a few more minutes. Um, about six of the actual podcast left. This is different than the content we had yesterday, is it not? This is different. They're definitely pulling some things out that we did not see in the live yesterday. So I find it very interesting. Normally, I wait till the end to take my notes. I definitely felt like I had to take some notes. It's very interesting. So I'm going to go ahead and jump back in. I just wanted to give you guys an opportunity to ask some questions if you had some, because they're segueing into the next portion. I can hear the transition. So I was like, let's jump in right quick. Any questions? Any questions? All right, hearing none, we're going to jump right back into this podcast.
Some degree of consensus backing from the elected representatives.
Precisely. And the third major change reinforces this corralling of judicial power, the creation of dedicated constitutional benches.
What does that mean?
Well, previously, the entire Supreme Court could get bogged down in endless political and constitutional crises, which paralyzed the ordinary justice system. Now, specific, dedicated benches are structured to handle only constitutional interpretation.
Got it. It is a massive recalibration. Parliament is pulling the rope as hard as they can.
They really are.
Okay, I want us to take a breath and zoom all the way back out. We have spent this time deep inside the engine room of Pakistan's legal system. We've looked at the dual operating system of the Islamic Federal Republic, the fundamental rights, the sheer power of writs, and this endless tug of war of amendments.
A lot of intricate legal machinery.
It is. But let's return to that impossibly tense room we started in, with the US on one side and Iran on the other. How does understanding this internal tug of war make Pakistan a heavy hitter in global diplomacy?
To connect those dots, we must apply the power in the room mediation analysis from the geopolitical presentation. That presentation explains why direct talks between nations like the US and Iran usually fail before they even begin.
Mhm.
It all comes down to power flow.
Write
Yeah.
down the power flows for those two specific countries.
If you look at the United States, its power flow is people to constitution, to
Right.
government.
Right.
The Constitution is the absolute, unquestioned highest authority. It is their secular sacred text. Every law, every presidential action must bow to the Constitution, which is derived from we the people.
Oh, look at Iran.
Iran's power flow is structurally inverted. It is religious authority to government to law.
Mhm.
Ah,
In their system, supreme religious authority sits at the very top. It is the ultimate veto power over the elected government and over any statutory law.
This is exactly what
Yeah.
you meant by different universes. I see it clearly now. When an American negotiator sits down with an Iranian negotiator, they are completely incompatible. So let me try an analogy here. It's like trying to connect two pieces of software using entirely different code languages. The US negotiator makes a demand based on democratic constitutionalism, and the Iranian negotiator system throws an error because it only recognizes divine mandate.
Yes.
Mhm.
Conversely, Iran demands respect for religious supremacy,
Right.
and the US system throws an error because it violates secular constitutionalism. They literally cannot process each other's inputs.
That is an excellent way to conceptualize it.
Mhm.
And this is where the geopolitical world often misunderstands mediation.
How so?
People assume a mediator must be a completely blank slate, a perfectly neutral party like Switzerland. But the presentation argues that true neutrality is an illusion.
Interesting.
In high stakes diplomacy, a mediator doesn't need to be neutral. They need to be understood. They need to have the hardware to process both codes.
Which brings us back to the skeleton key, the 1973 Constitution. Look at Pakistan's power flow based on everything we just discussed. It goes
Mhm.
people to government, to constitution, to the Islamic framework.
Right.
Yes. Because Pakistan is an Islamic federal republic,
Mhm.
it genuinely understands and operates on both ends of that geopolitical spectrum.
Right.
It runs a representative democracy, it has a bicameral legislature, provincial autonomy, and
Mhm.
constitutional supremacy. When Pakistan speaks to the United States, Washington recognizes a familiar democratic language.
But at the exact same time, Pakistan's constitution explicitly declares that sovereignty belongs to Allah. It mandates that laws cannot contradict the Quran and Sunnah, and it requires its highest leaders to be Sadiq and Amin.
Exactly.
Mhm.
So when Pakistan speaks to Iran, Tehran recognizes a familiar language of religious
Right.
authority.
Pakistan acts as the ultimate translation API. Its internal legal structure physically overlaps with both worldviews.
Mhm.
In international relations, power is ultimately about legitimacy. Can
Mhm.
you pass the stress test in the eyes of the nations you're mediating between?
And Pakistan passes both tests.
Pass both. It has enough ideological overlap that neither side will reject it from the road.
That is, I mean, it's honestly mind blowing when you connect it all. We started off looking at what seemed like dry academic legal text.
Right.
How a nation divides its provinces, how a citizen files a writ of habeas corpus, why a parliament changes how it selects a judge.
It sounds so purely domestic.
Right. But studying that internal rule book actually unlocked the mechanics of global diplomacy.
Mhm.
The internal code entirely dictates the external leverage.
It does. A nation's constitution is its DNA. And
Mhm.
just like in biology, that internal DNA determines exactly how the organism interacts with the rest of the geopolitical ecosystem.
We
I
have
like
covered
that.
an immense amount of ground today. We traveled from the foundational DNA of the 1973 Constitution, explored the profound dual nature of an Islamic federal republic, mapped out the rights and legal swords available to the everyday citizen.
The writs.
Yes, the writs. We navigated the historical tug of war leading up to the 26th Amendment, and finally arrived at Pakistan's highly specific role as a geopolitical translation API. It really changes the way you look at a map.
It definitely forces you to look past the superficial headlines and examine the structural realities driving global events.
Absolutely. And, if you're listening to this and you feel like an expert now, you could probably ace the 100 question multiple choice assessment for the University of London micro credential that these sources came from.
Probably could.
Yeah.
But before we wrap up, I want to leave you with a final thought to mull over.
Okay, let's hear it.
We have just spent this entire time dissecting how Pakistan's internal legal architecture creates its external diplomatic power. I want you to look at your own country, look at your own legal and constitutional DNA. What unseen doors does your country's internal rulebook automatically open for it on the global stage?
And perhaps more importantly, what doors does your internal blueprint permanently lock? Think about that the next time you look at the news and imagine who gets to sit at the head of the table.
Okay, you heard it here, right? Um, I like the analogies that this podcast. I like the one that we had yesterday. I did like those analogies. I think adding in the legally everywhere framework, the framework I made for this channel, I think that helped. It gave us some really good anchors. At least for me, these are some pretty good anchors. I like the analogies that this one came up with. Um, I like the call to action piece, right? Really sitting and understanding like what opportunities does it give you? Like, what potential opportunities to take away, right? Because we're talking about mediation, right? The goal is to come to a resolution. So we look at current events. Like when I say current events, I mean like 6 o'clock today, right? Like an hour or so ago, we saw that there were some strikes that went out, right? We thought there were some statements being made, and we know that we're supposed to be in a process of mediation. So my question is always, what actions that are being taken, um, do they bring us closer to a resolution? Do they kind of take us, steps further away from a resolution? Um, Operating in good faith, all these kind of things. When certain actions are being taken, I'm wondering like under what authority, right? Earlier this year, we heard that from a perspective, and I say we, like in the United States, we heard things being said like, hey, Congress didn't know about that. Or you listen to Congress members literally say, like, hey, we didn't know about that. Or we found out, when everyone else did, or maybe a couple of hours before everyone else did. Um, so then it makes you ask the question, like, under what authority, right? Like, what does our governance say? How things are carried out, how things are done. Um, these are questions that I always kind of have. So as I go through the course material, I'm always saying not just necessarily what pieces they require me to learn, but how does that affect my everyday life, right? If you're familiar with this channel, you know that I have the element of my Legally Everywhere framework where we talk about impact to the individual. That's more so the harm absorption element, because usually as clients, consumers, constituents, right? Civilians. We don't get to sit in those negotiating rooms, right? We don't get to sit as a member of those negotiations, right? So a lot of times when people are going in, they're negotiating for the best interest of the parties that they're representing, right? So then one question I would have is like, who are they truly representing? But that's another side question, right? They go in and they negotiate. Nobody's going to negotiate taking something that's a liability or a harm, right? So they shift the liability, they shift this, they shift it back and forth, right? Somebody has to absorb that harm, that damage, right? Oftentimes it becomes the client, the consumer, the constituent, the civilian, right? So when we arm ourselves with knowledge and a little bit of insight about the things that may be happening, even if we're not explicitly in the room, right? But we understand the mechanics of what can be happening in that room. We understand the doctrines that help give guidance to that room. We can then begin to put things in place for us to feel comfortable with making decisions that we can make, right? Because we do elect, at least in the United States, we do elect our officials. So if we know that we elect our officials, we arm ourselves with knowledge, right? So that we can elect the people who best represent what's best for our communities, our people, um, the constituency, the delegation, however you want to say it, right? You would elect the people who truly represent your best interests, because you also keep in mind that those people often are the ones who are making what the appointments. So those elected people and those appointed personnel, to a degree, you have some level of, let's say, power in selecting, right? So for people to feel empowered, know what's kind of going on. I mean, some of the stuff can be kind of dry, right? I'm not gonna pretend like, oh, this is just so good, this is so juicy. But you can make the process of getting this kind of information a little bit more succulent, a little bit more juicy, a little bit more fun to take in by using whatever tools and resources that you use. I'm studying and I'm using this AI tool to see how I can make it a little bit more interesting. I don't just study for the sake of just studying to pass the test. I study for full application. I study so that I can figure out how can we apply this? How can we be more engaged civically? How can we do our part in the community, right? It's not just to say just to know the information for the sake of knowing the information, but how can we make the communities that we live in better, right? So that's kind of where the mindset of today was. The question is, under what authority? Like, what guidance are people having going in? Because if you understand that too, the people who are sitting, let's say, in opposition, right, are operating with guidance that kind of would give them to more pause on certain things or to lean in certain directions, right? That aren't necessarily, let's say, parallel. And you have someone who literally can go in between the two and say, I get you, I get you. I want us to come to some type of understanding so that we can make decisions and have an outcome that we better for the constituencies that you both have, right? The people. Because when you guys are sitting in conflict, the civilians for which you're supposed to represent, they are absorbing that harm. The conflicts that are currently going on, the people, we're the ones that's absorbing that harm. Whether it's you going to the gas station and you're like, what is going on? Whether it is, your access to food, whether it is maybe your status has changed, whether it is just your general comfort about conversations or going to certain places or traveling or whatever, right? As a civilian, we absorb that. So it's important for us to be informed, because once we're informed, we can start to formulate a plan and a course of action to how we want to cope with said event, right? With said outcomes, right? So we have a couple of opportunities for things for us to do, and it's just up to us to figure out what we're going to do, how we're going to motivate ourselves and equip ourselves to handle the things that we're dealing with, because we can, right? I like people to feel empowered. I don't like to have um conversations of fear mongering or just saying, oh, let's look at this headline, rah, I don't like that. I like to go look for the doctrines and read them. I like for us to just look at the foundation. I like for us to try to understand the overall impact, because it's not just one thing, it's often multifaceted conversations. So that was the point of today. I was just really curious once I took all of my notes, and you guys know I have kind of a specific way I tend to look at things. I was curious, what would AI say if I threw it into that system and I said, hey, this is the framework. These are the notes I've been taking. This is actually what I'm supposed to be, responsible for knowing. I put that in there too. Uh, this is a previous presentation I kind of did relevant to mediation, right? What do you think about this content? Like, give me a podcast. Let's talk. You know how I feel. Let's talk. Let's learn out loud. So I was pleasantly surprised by that content. I don't know how you all felt. Yesterday's podcast that they came up with was 19 minutes. Today was 23. At the core, mostly a lot of same things, right? But really, they were having some different conversations. When we changed that lens, we did have a little bit more conversation that dove into different areas. So I was pleasantly surprised. I very much like that. I think we'll continue this. We'll make this a full series. I'll kind of jump and move through as I move through my Pakistan law material. Um and I have a mediation one that I'm doing as well. As far as assessments go, I'm not allowed, based off, contracts and things like you don't when you're in school, you're not supposed to give like your actual lecture. So I can't give you or produce that to you guys. Normally if I can give it, I'll give it. I'm not able to give you that, but I can give you the study materials that I have, and I can create things like this. So hopefully, if this is something you were interested in, you're like, I just didn't have an access point or entry point, you have one now. Let me be your plug, right? Let me be a plug. Get you set up right, right? But no, in all seriousness, I just don't feel like certain information should be gatekept. I feel like we should be able to talk. And learn together. So that's what we're doing today. Hopefully you enjoyed this. I had a blast as always. Um, I looked in at the comments. I don't see anything specific to the content, but I 100% appreciate the engagement. I appreciate the subscription. I appreciate you guys being present with me as I was studying a little bit today. Once again, I just really appreciate the dialogue, the content, the engagement. Um, as I am building out this channel, but also as I am studying and I'm learning, and I am once again just trying to do my part with civic engagement, and just helping make sure certain information is accessible in the community. Once again, thank you. This is Legally Everywhere with Child. We'll be looking into everything. This is Adrian Wood signing off, because it's time for me to have a snack. You have a wonderful evening or morning wherever you are. Greetings, salutations. Good night.